Well, Alderman Lady, when we broke yesterday evening, I think indicated, certainly intended to indicate, that we'd basically come to the end of certainly my submissions about the EU law obligations, and what I wanted to turn to, because with those in mind, it's obviously necessary to look at the immigration rules.
Yes.
At the time of decision, and certainly I would submit that's obviously the material time, because that's where the rules that the Secretary of State was meant to be applying, and according to SIAC, wrongly applied. There are three features of the rules that perhaps need to be highlighted. Firstly, you probably have these before you, but I think they've already been highlighted to some extent, but I want to emphasise them for our purposes. Firstly, what the rules do is, in 33(8)(a), is make it clear that refugee status can be revoked, and they can be revoked if 339 rather AC applies. That is obviously a reflection of the concept found in the Qualification Directive of revocation, but not found in the Refugee Convention, of revocation of status. It's a reflection of the fact that there is a grant of status as a matter of domestic law and EU law. The test then applies, it is in 339AC, and that, as is not in dispute, uses the same language as the Qualification Directive, the reasonable grounds test. It is also correct, as was pointed out yesterday, that the rules make reference to the qualification regulations, the 2006 regulations, and so in my as I understand it, nobody challenges what was said by SIAC at paragraph 168, which is that transposition of the Qualification Directive was achieved by a combination of the immigration rules and regulations. Further support for that, if it's needed, is in the authorities bundle in an explanatory memorandum to statement of changes to the immigration rules HC 535, which came in on the 29th of October 2015. I should say we have a copy of HC 395 if you wish it. It's a relatively lengthy document, it's about 57 pages, and there's no dispute that what it did was insert the particular phrase that is in issue in this case in relation to in Rule 339AC. In other words, it inserted the reasonable grounds test. Hand it up if you need it, but I suspect we've already handed up quite a lot of papers, and it's just another piece of paper. But because, as I say, I don't think there's any dispute about having. Well,
if we don't want all 50 pages, but if you've simply got the front page and the relevant page, then
I will ask my learned junior to do that for you.
Thank you.
The key paragraphs are 7.9 to 7.11. And you'll see there that what is made clear, consistent with the definition of revocation that is then inserted into the rules, is that the view of government essentially was that the Qualification Directive enhanced the ability to address threats to security, and as a result, it was important the immigration rules took full advantage of that power to revoke. So what that demonstrates was that there was a deliberate decision to go as far as permitted by EU law in revoking in circumstances of national security. So in our submission, there can be no doubt that the particular provisions in issue in this case were intended to go as far but no further than were permitted by EU law. We do, of course, have the more recent immigration rules that applied at the time of SIAC's determination. In our submission, they don't really change what I've just said because they still apply the reasonable grounds test. They do that by reference to the Refugee Convention because there's a reference to the Refugee Convention added, and certainly our submission is that they are the same. But more importantly, what SIAC focused on was the decision-making of the Secretary of State. So that must be, the approach of the Secretary of State must be set against, obviously, the rules that applied at the time. And the rules that applied at the time were the first set of rules you have. Yeah, 11A. As I say, as far as we can see, there's no material change between that and the version that was introduced in HC 535. Should say, of course, that as my lady pointed...
There is a difference, I think, which is that the reference to the 2006 regulations has gone from the second version.
Sorry, my lady, I probably wasn't clear there. What I was saying, there's no material difference. There's no material difference between the language adopted in HC 395 and, sorry, HC, not 395, that's the overall immigration rules, HC 535 and the rule that applied at date of decision. I accept there's a material difference at the date of the appeal hearing, which is, as my lady's pointed out, the addition of the reference to the Refugee Convention. My point in relation to that is that that doesn't change the meaning of the phrase for the reasons I went into yesterday.
Okay. Sorry,
and
it's
also,
my fault, I just misunderstood.
Sorry, no, I'm sure that was my fault.
Thank you.
Obviously, and it links back to the point I was just making, which is that we say that support for the approach of SIAC is also found in UNHCR material and understanding of the Refugee Convention. The immigration rules are required to comply with the Refugee Convention because of, and Milady made reference to it yesterday, the reference, and it's in the authorities, is the Asylum and Immigration Appeals Act 1993, Section 2.
Yes, it doesn't go quite as far as requiring the immigration rules to comply with the Refugee Convention. It's a negative prohibition.
It is negative.
The rules can't lay down any practice which is contrary to the Refugee Convention.
Absolutely, that's right. But it means that these sort of provisions we're looking at can't be inconsistent with the Refugee Convention. That's a better way of putting it.
Well, or if they are, they're ultra vires.
Yes. Yes. But I don't. Yes. I'm sure anyone suggests that in this case.
Can I ask it, the current version of the rules, the heading is revocation of refugee status in 338A, and then dangerous United Kingdom 339AC.
Yes.
What is said must be satisfied is Article 33(2) of the Refugee Convention.
Yes. Yes.
But that, of course, isn't dealing with the term.
Well, except it goes back to the point I was making yesterday, which is that as a matter of domestic law, the only protection, there's no immigration. What the qualification directive appears to envisage is that you could have a system where you revoke someone's status and then the individual can potentially rely on Article 33 at the point of removal. The point I was making yesterday, which is the point that SIAC was making, is as a matter of domestic law, we don't have, as far as we can see, any separate... So as a matter of domestic law, as soon as your immigration state, your refugee status is revoked, in principle, there's nothing in black letter law that prevents you then being refooled. All you could potentially do is if you haven't challenged the revocation, and obviously there are rights to challenge the revocation, but if you haven't challenged the revocation, SIAC's concern was effectively how are you then going to be able to challenge it?
Well, isn't it the other way round? The test for revocation is the same as the test for refoulement.
Yes, sorry. The reason I was saying making that linkage is because the point I think my lord was putting to me was that the rule in one sense is an oddity because it imports the language, it expressly imports Article 33(2) when in fact what is in issue is not refoulement in 339AC. What is in issue is revocation.
The rule makes revocation dependent on the Secretary of State being satisfied that he could reform.
Yes, and it's absolutely, my lord. And the point I was trying to make, perhaps unhelpfully, but the point I was trying to make was that fits with what we were saying yesterday, which was as a matter of domestic law, there isn't this, to the extent EU law would have permitted a two-stage process of revocation followed by consideration of refoulement. Our domestic law doesn't provide for that. It imports the refoulement test in 39.
Well, it makes good your point. The test must be the same.
Exactly, my lord. Yes, exactly. I was putting that a very long-winded way, but exactly, that's my point, yes.
Well, it's not just the tests. Forgive me, it's not even that the test's the same. There's only one test.
Yes. Yes. And my lord, can I just briefly recap in one sense where we are before coming to the 2018 Act? Ignoring the 2018 Act, what in our submission is clear is that the immigration rules at the time of decision were intended to comply with EU law. They also couldn't be inconsistent with the Refugee Convention. That intention, in our submission, there's no obvious reason to believe that there's any basis for adopting a different approach to the interpretation and failing to take account of that intention, despite Brexit, because the rules didn't change, there was no attempt to amend them. And so at the very least, ignoring the 2018 Act, in our submission as a matter of first principles in one sense, there is good reason to at least take account of the CJU case law as relevant. There is also good reason to take account of the UNHCR guidelines as relevant.
Well, I'm struggling at the moment to see why it matters whether or not the position in relation to the qualification directive, because everyone accepts that it has been implemented and the wording is the same.
Yes.
And you don't rely upon anything specific in the qualification directive, you rely upon the guidance from the UNHCR.
Yes.
And that guidance, as we've seen from AAA, applies to domestic legislation as much to European legislation.
Yes.
So what does it matter to you whether or not the qualifying directive is retained? Well,
in one sense, that was the point I was just making, really, was that before even getting to the 2018 Act, those arguments are good arguments in our submission, and that's why I started the way I've done. The only reason why the 2018 Act may be relevant is that we would say, if where I've got to so far is not as I've just submitted, then the 2018 Act makes it clear that SIAC was correct to effectively reference the judgment of the CJU in T. And it does.
But given that these immigration rules are derived from the qualifying directive, I can't see how the court could be prevented from referencing the qualifying directive in interpreting them.
Well, my lord, I agree with that, obviously, unsurprisingly, and that was in one sense the point I was just trying to make. what in one sense our position is in relation to the 2018 Act, and if it's not going to assist, I can go ahead. But what we say in summary in relation to the 2018 Act is the way the 2018 Act it operates is effectively to give a statutory effect to what my Lord is saying. It's the effect of it is to say, if you had a legislation that was, and legislation has a broad meaning, I can come on to that because I know the concerns of my lady, but what it effectively says is that if you had legislation intended to comply with EU law, it continues to have effect in that way, and you continue to look at judgments of the CJEU. Well, in one sense, that's consistent with common sense. It's just giving statutory effect to that. And that's the way in which we submit the 2018 Act operates. So all it does is underpin the point my Lord was putting to you. And that's in essence what our position is in relation to that. Now, I hope it assists the court in one sense to go through our position on that, just because it is an issue before the court and it's an issue that may have relevance in other cases. So I hope it assists to go through it. But I completely accept in one sense the point that I don't necessarily need to go there, because the sort of proper approach to interpretation of legislation, or of the immigration rules to be more accurate, would suggest that we can rely on EU law in the way that's just been put to me by my Lord.
Well, given though that what you rely upon for interpretation of these words in the qualifying directive,
yes,
is the UNHCR, and given that the words are the same in the domestic legislation, why does it make any difference?
Well, the reason it might make a difference, and the only reason it might make a difference, is obviously the focus of SIAC was more on T, and we have also relied on T, and we say that T, what the 2018 Act does is give a statutory basis, essentially, for reliance on T.
I see.
So sorry, can I just clarify one point?
Yes.
My Lord referred to the UNHCR. Is my Lord actually referring to the Refugee Convention? Or to something the UNHCR has said?
No, I'm related to the guidance.
Oh, the guidance.
But I will try and go through, because in our submission it's relatively clear that the 2018 Act relatively quickly. The starting point, obviously, is as we've submitted in our submission, is section 2 of the 2018 Act, which makes it clear that EU-derived domestic legislation continues to have effect. I should say, what you have is the version that was being applied by SIAC. You'll see that there were amendments. The original version of the Act referred to the exit day, I think it was, which was obviously the slightly earlier day than the implementation day, but it had the same concept. It was still intending to obviously continue the Act, basically. I handed up yesterday because it helps to understand that, because obviously the references to legislation, section 1B of the 2018 Act, which was also in force at all material time, and that defines EU-derived legislation, and it is in our submission a broad definition, because it includes anything relating to the EU and an enactment relating to the EU. An enactment is given a broad definition. If you go to Authorities 9, section 20, you will see, section 20, which is page 20, which is page 19, you'll see that enactment includes any instrument made under an act. And section 3 of
where are you looking?
Sorry, it's the bottom of the page, page 19, you'll see about 7 or 8 lines up, enactment includes an enactment contained in a lengthy set of terms, and then at the end, other instrument made under an act.
Yes, I see. Thank you.
We handed up yesterday the, actually I'm not sure we did hand up, we have copies of that available, Immigration Act 1972, I thought we had handed up.
72 or 71?
71, sorry.
I don't think you did.
Yes, sorry, I'm not sure where. The additional authorities. Can we? I know, I found it. We have copies here of the Immigration Act 1971. Thank you. And it's section 3.2 that is the effectively the statutory basis for making immigration rules. It's at the bottom of the first page. And it's, may or may not matter, there is a mandatory duty essentially to make the immigration rules. And that was what was in issue in the authority I handed up yesterday, Alvey. In Alvey, the issue was, and my lords and my lady may remember this, it used to be the practice of the Secretary of State that you had relatively brief immigration rules and pages of guidance. And Alvey changed that on the basis that because they were, many of the things contained in guidance were in fact practice as to admission, they needed to be in the immigration rules. And in that context, the Lord Hope delivered certainly one of the key judgments. Para 34 onwards set out effectively the the way in which the 1971 Act operates. It links to the point my lady made, which is that the immigration rules have a sort of longer history, because the point he made in particular about paragraph 34. Paragraph 34 is that the purpose of the 1971 Act was to bring immigration rules within parliamentary control. Now, that in one sense, we would submit is sufficient for the purposes of section 1B7, because it's clear that the immigration rules aren't simply a policy, they are a form of law that, or they're an instrument, perhaps more importantly, is a better way of putting it, to reflect the language of the 2018 Act, made under primary legislation. And that, we submit, is sufficient. And the reason for that, in one sense, that broad definition, we would submit, the primary reason for that is because what the concern of Parliament was it didn't want a cliff edge in relation to any of the many instruments that are potentially made under legislation. It wanted them to continue to have effect as before, unless there was an express decision by Parliament, or an express decision perhaps even doesn't necessarily need to be by Parliament, but unless there was an express decision relying on primary legislation to change those instruments. Now that, in our submission, my lady was raising, as I understand it, the question of what is ultimately the legal effect of immigration rules, which is the primary issue in Odolola, which you also have, I think. And we submit, in one sense it doesn't come into that, but to the extent that you need to consider that, it is also worth looking at paragraph 38 of Alvey, which is Lord Hope considering Lord Hoffman's judgment in Adalola. it's described as MO there because it's sometimes known as that, but from the reference it is obviously the same case. Who talks about, and Lord Hope understands Lord Hoffman as having decided that immigration rules do give rise to legal rights, and we submit that is right, that has to be right on the basis that at any one point in time, someone who is entitled to enter under the immigration rules is entitled to rely on them. Now, the issue in Odlola was essentially about whether or not, as I understand it, there's freedom to change them in circumstances that potentially prejudice someone who's relied upon them. And in that context, it was held, for example, by Lord Brown that they are an indication about how policy will be exercised at a particular point in time. The reference to that is paragraph 35 of Odlola. But as I say, I'm going through that fairly quickly because in our submission, none of that matters. The key issue is not what the effect of the immigration rules is, it's the fact it's made under the Immigration Act. And so we submit that my learned friends...
Sorry to interrupt. There are one or two statements in the speech, whether they're speeches or opinions in Odlola, which along the lines of they're statements of policy, not legislation. I mean, do you want to deal with those, or do you say they're irrelevant? Well,
my lady, the point about that is obviously in one sense, they're not legislation. They're not primary or secondary legislation. They're not enacted through that legislative process. And so in some contexts, they clearly aren't legislation. That's why in one sense, though, it's important to look at the definition in the 2018 Act. And the 2018 Act is clearly goes beyond the normal concept of legislation. It deliberately defines legislation by reference to the word enactment, and then it then gives this broad definition of the meaning of enactment, which we submit is consistent with this basic idea that what Parliament was seeking to avoid is is what I described as a cliff edge. It's the sudden change of lots of pieces of legislation.
As I understand it, what you say is that they are statements of practice, that's the word in the Immigration Act 1991, contained in an instrument. Which instrument is made under Section 3.2? Is that the same
exactly,
of what you're
Lord,
saying?
that's exactly the point I'm making, and that's the key. The key. As I say, legislation can mean different things potentially in different contexts, but the language here that you need to consider are the statements of practice in an instrument made under an act, and we say they clearly are because of Section 3.2.
Yeah, I see.
And as I say, I pointed to one of the objectives of the 2018 Act. We submit there's another objective, essentially, which is to another objective of the 2018 Act, which is to ensure that, again, save where repealed, there is comprehensive continuation of the rules and standards imposed by EU law, which is why, for example, Section 4 allows you to rely on, or allows a person to rely on concepts of EU law, save where they've been expressly repealed, such as in the 2020 Act. And both those purposes are consistent with the submissions we've made about the need for a wide interpretation of what is meant by enactment. And it's why such a broad definition of enactment is included in the 2018 Act. The effect of that, the reason why, in one sense, that matters, and it goes back to the point about the status of T, is if one then goes to page 15 of the Authorities Bundle, section 6, you see that any question as to the meaning of any retained EU law is to be decided so far as the law is unmodified, and obviously at the date of decision it was unmodified, in accordance with any retained case law, and this is clearly retained case law because it predates exit. Retained case law, I should say, is defined in subsection 7 of the of section 6, which is at page 17. Now, AAA is obviously what my learned friend relies upon. AAA is clearly concerned with a different circumstance, and it's a different circumstance that arose by reason, effectively, of the terms of the 2020 Act. It was not concerned with an unmodified provision of domestic law covered by Section 2.
Your point is it's concerned with a completely new set of provisions in the immigration law.
It was, and what the individual needed to do was rely on underlying provisions of EU law which would have had direct effect. And the whole purpose, well, there are two purposes in our submission when one looks at the 2020 Act as a whole. Firstly, what it does is, in an immigration context, it repeals directly effective provisions of EU law that are inconsistent, or might be said to be inconsistent with domestic law. So it prevented the sort of challenge, plainly it prevented the sort of challenge that was being brought in AA. Secondly, it repeals some provisions directly. So it repeals some provisions that would be caught by Section 2. But that's not this case, obviously. It's the earlier parts of Schedule 1 that do that. Now, my learned friend makes two submissions in writing that I don't think he's particularly advanced orally, but may relate to this. One is you can't adopt a different approach to national security in this context. And he points to, which was a concern of SIAC, the approach potentially to deprivation of citizenship. Firstly, in our submission, there's no obvious reason of principle why you can't adopt a different approach. The statutory tests are different. They have different origins. It might seem slightly odd that, if my learned friend's arguments are correct, refugee status might be said to attract a higher level of protection. But if that's the decision that's been made by Parliament by adopting different tests, in one sense, so what? That's not a value judgment that's necessarily open to this court. But the only thing I would say about that is, of course, the approach as a matter of domestic law, even in the context of citizenship, is perhaps slightly more nuanced than my learned friend suggests. So, to give an example, it's in the authorities bundle, FAM, page 210. FAM was a case of deprivation of someone who, although technically a Vietnamese citizen, was unlikely to get any real benefit from his Vietnamese citizenship because Vietnam was refusing to acknowledge him. And Lord Mance, who was in the majority at paragraph 98, indicates because of the significance of deprivation of citizenship, at least in that context, there was a need to consider proportionality. Now, of course, that doesn't mean you don't give great weight to the views of the Secretary of State, but by implication, the Secretary of State needs to be satisfied that the justification is sufficiently powerful. It's not any justification. And that's really in our submission the origin of the UNHCR approach. So it's not clear necessarily, as my learned friend says. It's not clear really whether there is that as much of a difference between the approach SIAC adopted in this case and what is required as a matter of domestic law in different contexts. But as I say, our primary point is that doesn't really help you because the provisions in issue have a clear history that give a clear indication about their intent. The other point that my learned friend has relied on at times, I think in his skeleton argument, is Section 34 of the Anti-Terrorism, Crime and Security Act. I'm not going. I'll deal with it in. I don't think my learned friend has addressed that orally. In our submission, the reasoning of SIAC at paragraph 187 in relation to that is compelling. It is essentially to say any provision in this context has to be interpreted narrowly because it's potentially impacting on someone's status as a matter of international law, and what it's describing is a different issue, a different approach to the last resort approach.
Sorry, I'm not quite sure I'm following that.
Sorry, I was dealing with it probably fairly quickly.
Can you maybe just unpack that a bit,
Yes.
please?
If you go, it may just be worth looking at it, the provision. If you go to Authorities Bundle, page 11,
Yeah.
you see there section 34, and the relevant provision.
Sorry, which tab is it? It's my fault.
Oh, sorry, tab 4. I haven't.
Tab 4. Right. Sorry.
Sorry, the version I have hasn't got tabs.
No, I've slightly interpolated other bits and pieces,
Right.
so yeah, thank you.
It's the relevant provision is section 34(1)(b), which applies that there's no requirement to consider the gravity of the threat by reason of which section 33(1) applies. So what that is a reference to, obviously, is the threat in 33(1) is the threat to the security of the individual. It's the threat to the person. It is the threat of ill treatment. If you need the reference to the Refugee Convention, that is at page 39. And 33(1) is the provision that says you can't be expelled to the frontiers of a territory where you will be threatened on account of race, religion, etc. So the threat that's being referred to.
Sorry, is the threat described in 33(2)?
No, it's the.
Oh, sorry, I'm so sorry.
Yeah.
By reason of which 33(1) would apply.
Yeah.
Okay.
Yeah. So it's simply saying you don't have to consider whether the threat of ill treatment is really bad, extremely bad. That sort of gradation of threat is not something that needs to be considered, which is not what's an issue in this case, effectively, and that's the approach SIAC adopted at paragraph 187.
Sorry, can you remind me where the relevant bits of the Refugee Convention are?
39.
39.
Page 39, which is tab 12. Tab 12.
I just want to make sure I've understood it. I'm quite slow.
No. It certainly took me some time, but having read it repeatedly, I think I understand it now.
Yeah, probably haven't. I almost certainly haven't read it as often as you have.
Remember, the language in 33(1), while you've got that in front of you, if you've now got the Refugee Convention in front of you, is no requirement to consider the gravity of a threat by reasons of which Article 33(1) would apply if Article 33(2) did not apply. So it's focusing on the threat in Article 33(1), and the threat that is referenced there is the threat to life, freedom, etc., on account of race.
Yes, I see. Okay, thank you very much.
So,
no, thank you for explaining that.
no, No problem at all. And that's, as I say, SIAC said, well, that's not what's an issue in this case. The reference to that is paragraph 187. And we say that's right. Then come to the respondent's notice, and essentially there are two issues that arise in relation to that. The first, in one sense, is linked to the points we make in response to the appellant. And the point we make in response to the appellant is, in one sense, quite a simple one. SIAC directed itself, but it links very closely, in one sense, as I say, to the points made in response to the appellant.
I'm so sorry to interrupt myself. Can we just get back to 187?
Certainly, yes.
Do you agree with the first sentence of 187? Do you agree with that part of SIAC's analysis?
We would agree with that in the sense that to the extent section 34(1)(b) is intended to restrict the scope of protection against refoulement, then it must be strictly confined. That having been said, in one sense, I don't think it really matters for the purposes of my argument, because the key thing is it is quite.
No, but I'd just like you to focus on whether or not you agree with what SIAC says in that sentence. So, all the provision precludes. I mean, do you accept that section 34(1)(b) precludes a proportionality exercise? This is the level of danger to national security against the level of danger to the individual if required.
Sorry, I thought you would.
Sorry, it's my fault. Second sentence.
Second sentence.
Yeah.
In terms of the second sentence, I would say that goes further, in fact, than section 34(1)(b), because all 34(1)(b) is saying is you don't sort of look at, is the risk high, very high, extremely high of ill treatment. That doesn't necessarily prevent a proportionality bet, but because you can say there is a risk, and against that, this is the justification.
Right, I see. So you don't necessarily agree with sentence 2.
No, because I agree with section 1, sentence 1.
Yeah.
Sentence 2, in our submission, if you strictly confine it, all 34(1)(b) says is you don't grade the degree of risks of ill treatment. So you don't say this is someone who's at particularly high risk of being tortured on return to wherever they're going to go to.
But if you can't grade the risk of ill treatment, how can you balance the risk of ill treatment against the danger to national security?
Well, two things about that. Firstly, our starting point would be that you know that on one side of the balance, the individual is being denied a fundamental right, and you look at whether or not the justification is sufficient. Secondly, in one sense, for the purposes of this argument, I'm not sure I need to go as far as that, because what we're saying is that when interpreting the Refugee Convention, in particular 33(2), two factors, they're independent factors, but two factors need to be applied. One is measure needs to be of last resort, because otherwise, if you use the language of UNHCR, there's no rational connection between removal and threat, because you can manage the threat in some other way. That's not necessarily about balancing. SIAC introduced a balancing test. We don't disagree with that, because otherwise, to some extent, you could say, well, any way of managing risk, no matter how expensive, no matter how impractical, would potentially prevent removal. And that's what SIAC did, we submit. The fundamental question is, should refoulement, in the context of Article 33(2), be a measure of last resort? The second point that we're making, which is where I'm coming to now in terms of the first issue we raise in our respondent's notice, the second issue is is any danger effectively to national security sufficient, or must there be a relatively high threshold crossed? And that's not necessarily the same as carrying out a balancing exercise in an individual case. It's simply recognising that as a matter of interpretation, on one, that 33.2 effectively is an exception to a fundamental right, and so there needs to be an adequate justification for it, which is what UNHCR is essentially saying in its guidance.
And who decides whether the justification is adequate?
Well, we've put in our respondent's notice an issue about who decides this.
Yeah.
But I think I said yesterday, and I having considered it overnight, this remains my position, that the more there is an element of judgment in the test, so the more that the test becomes the more the test becomes not simply is there a danger, but whether that danger is sufficiently high to justify the action, the more it becomes the sort of matter that where applying the approach in applying the approach in Begum, SIAC has to respect the judgment of the Secretary of State. The question becomes more whether the Secretary of State has taken on board that need for a sufficiently high justification. That's why, to some extent, our final, the second point we make in our respondent's notice, only works essentially if we've lost on the other 2 points. I hope that makes sense, my lady, as an answer to that question. It may not be the right answer, but
And other than the route that SIAC held was the right route, i.e. balancing the cost of measures falling short of refoulement against the other things. I mean, is there any other way of doing it other than the way that, I'm sorry, I'm not expressing this very well. Is there any other way of doing it other than the way that SIAC chose, is really what I'm trying to get at?
well, as far as I can, in terms of the issue raised by the Secretary of State's appeal,
Yeah.
the way in which I've approached it, which is, and I think the answer in short is probably no, practically, but the way in which I've approached it, just to expand on the reasons for reaching that conclusion, is the approach of UNHCR, and indeed the approach of the CJEU, indicates that Article 33.2 must be interpreted as indicating that refoulement can only be used as a last resort.
Yeah.
And we say, for the reasons I've gone past, there's good reason for that.
Yeah.
If it's a last resort, that means, by implication, that other methods of dealing with the risk have to be considered, because if they're not, it can't be said to be a last resort. As far as we can see, and I may be wrong about this, but as far as we can see, there are only 2 possible ways of considering alternative methods of managing risk.
Yeah.
One is to say, well, any method of managing risk, no matter how impractical, no matter how expensive, no matter how much that impacts on the protection of state in other ways, any method of protecting risk is a bar to revocation, is a bar to refoulement. That's a pretty unattractive position for me to take, and I recognise that's a pretty unattractive position for me to take. Yeah. So the alternative is that there is some consideration of practicality, and given the sort of importance attached to proportionality throughout sort of international human rights law, the obvious way of dealing with that is proportionality, and that's what we understand SIAC to be saying. Are the alternative measures proportionate? And they're using slightly longer language to express that concept, but that's fundamentally what we say they're saying.
But is what SIAC's really saying, are there less intrusive means rather than, because I'm not really sure whether it's a proportionality test or whether what they're really asking themselves is whether there's a less intrusive way of going about this.
Well, the reason I use the word language of proportionality is it comes from para 194, and where they do talk about balance, it's page 110 of the core bundle.
Yeah.
And that's where they also talk about cost practicality and feasibility. And how I've read that, and I may be right, I may be wrong, is what they're fundamentally trying to describe is a test which is meant to address essentially the proportionality of requiring the state to use some alternative mechanism for managing risk.
I see.
And if that is the right concept, that's why, as I say, we end up with the position we've ended up with, which we can't really suggest any alternative to. Because I mean, off the top of my head, one way potentially of analysing that, and this is not something I've thought about until my lady put the question to me. My lady may remember that in Osman, the European Court of Human Rights needed to grapple with the problem of what obligations are imposed on the state to police against someone who is a high risk of offending. And the approach of the European Court of Human Rights was ultimately to apply an obligation to take reasonable steps, and one of the things that there was a requirement to take account of is that the practicalities of modern policing, I think from memory, was the language of the European Court. So it wasn't, again, it had this choice between essentially, did the response need to, was all the state required to do was provide a proportionate response, or should it put every resource it had into protecting the individuals who are at risk in the Osman case? And in the end, it concluded essentially it was the lesser obligation, reflecting the realities of modern policing. And you can sort of import that concept, and that's certainly how I read it, how you end up with paragraph 194.
I see. Thank you.
While we've got SIAC open, and it's almost it's slightly before the passage I just took the court to. If you go to paragraph 189, you will see SIAC rejected an argument that the UNHCR approach. This was something we talked about yesterday about the approach to the UNHCR guidance generally. They rejected a specific submission that danger essentially meant serious danger. And they did that relying on two authorities that I'll take you to: a judgment of this court in a case called EN Serbia, and a judgment of the upper tribunal in a case called AA Palestine. And you will remember that the language of UNHCR, it's at 654, the guidance. I took you to it yesterday. It's paragraph 14, Roman 1. The language of UNHCR in its primary paper was very serious. 658, it slightly the second paper uses slightly different language. Roman 3, the danger must outweigh the risk of harm to the individual. What we submit fundamentally is that what that guidance really is concerned with is the fact that danger read in context, and this is in our submission what the UNHCR guidance seeks to do, danger read in context must mean something more than simply there being a danger. It must be a danger that is a sufficiently compelling justification for denial of refoulement. Now, in support of that, obviously we rely on the UNHCR papers, and we rely on
to allow rather than to deny.
Sorry, yes, to deny to allow reform. Yes, sorry. We rely on the UNHCR papers, and we rely on AAA and what was said about UNHCR in that context. The two judgments that were relied on by SIAC are firstly EN Serbia, which is in the authorities bundle at page 112. The relevant passage is, I think, at 112. Tab 16. Yes, sorry. The reason I've gone to 112 is that it's important to recognise in Serbia that what was an issue was the second limb of 33.2. It was the provision that deals with particularly serious crimes. And that's important because when one looks at what is said by the Court of Appeal recognised that in a context where you already had, in one sense, a high threshold imposed by the use of the language of particular serious crime, in that context, you didn't need, in one sense, any other sort of high threshold to be imported. And we're obviously looking at 33.1. And the court recognised the distinction between 33.2, sorry, we're not looking at 33.1, we're looking at the first limb of 33.2, and the court was looking at the second limb of 33.2. And the Court of Appeal, in the judgment of Stanley Burnton, Lord Justice, recognised that distinction in para 39. It, at para 45, say, placed emphasis on the words particularly serious crime as restricting, to use the language of the learned judge, to restrict drastically the offences to which the article applies to.
Sorry, it's my fault, Mr. Sully. Which paragraph have you moved?
45,
to? 45. Sorry. No, it's my fault. Thank you.
All of that means that the passage that SIAC relied upon in our submission shouldn't be applied in this context, this different context. The passage that SIAC relied on was paragraph 43, where what was being cited was actually, I think, not the material that you've got. It's material in the that was essentially an opinion prepared by two learned experts on the in this field, as well as a passage from an academic text. and those materials were rejected as placing a gloss on Article 33.2 which was not justified by its language. In our submission, that is very different from what you have before you, in that you have before you an opinion on the correct meaning of the convention, which is justified essentially on the basis that one has to interpret 33.2 as being a carve out from 33.1, so there has to be a threshold. And so we submit EN survey can be justified essentially for three reasons. Firstly, it's not concerned with the first limb of Article 33.2. That is significant because it doesn't have the sort of protections that exist in relation to the second limb. Secondly, what you have is not sort of academic opinions on the approach. What you have is an opinion from positions rather taken by UNHCR on the interpretation of the convention, and they are positions which we submit reflect the need to interpret the convention in context. And thirdly, because of that, this isn't about putting about changing the meaning of the convention. It's about interpreting the convention correctly. The second authority relied upon.
So the main, sorry to interrupt. The main point about paragraph 43 is what would its owner say, because Lord Justice Stanley Burnton says that it's an unjustified gloss to say that danger means very serious danger, and your point is, well, that's not what the issue was in that case.
Yes.
Right.
Well, it was the issue in relation to the second limb. It was not the issue in relation to the first limb.
Right.
It'd be odd to say that you can't gloss danger in the second limb, but you can gloss it in the first limb.
Well, except, my lord, and that's the reason why I came to it. Two things. Firstly, and this is probably the most important one, the second limb has, by use of the words particularly serious crime, an inherent restriction within it. It is
no, not on the word danger.
No, but you are
two concepts. There's the crime and there's the danger.
But my point is, you only get to that issue, that point of considering danger, once you've got through that threshold of there being a particularly serious crime, which is the point that's made in para 45. Para 45 says the words particularly serious crime are clear and restrict drastically the offences to which, and the second point, which it would, is that because of that, in part, one can see why UNHCR expressed the opinion they did, which is a legal opinion. It's not about changing the meaning of the settlement. They expressed the opinion they did, that there needs to be some restriction. It can't just simply be any danger.
I can't see the link between. I can't see that a particularly serious crime has necessarily any impact on the extent of the danger. I mean, somebody might commit a very serious crime, but now be in a vegetative state in hospital. They wouldn't pose any danger.
Well, if they don't pose any danger, then they can't qualify. But the point I'm making is that
but it's a matter of degree, isn't it? And the extent of the crime is on one side of the coin, then how much danger do they pose is a different question.
But the point I'm making, my lord, is that the position of UNHCR in relation to danger is derived from the basic idea that 33.2 is a departure or is a denial of the basic writing of 33.1. So UNHCR, fundamentally, the logic of their position, as I understand it, is to say, because it's a denial of a basic right, it needs to be restricted in its application. What, in my submission, Lord Justice Stanley Burnton was recognising in para 45 was because of the language of particularly serious crime, its application is very restricted because it's only you only get through that first hurdle in a small number of cases, essentially. In this case, if you look at the first limb, if it simply means danger, that's not necessarily, because it's not saying that's not necessarily very much a restriction, and it's in particular not a restriction that necessarily reflects the seriousness of the consequences for the individual. That's the distinction I'm...
But the point that goes the other way is that subparagraph 2 of paragraph 2 of Article 33, which is something that a whole load of different states signed up to, shows a recognition in the drafting that there are different degrees involved in these judgments. And the word danger isn't qualified in either limb, whereas serious crime is qualified, particularly serious crime. Well, it's qualified in two ways. So the argument the other way is, well, look, the draftsman has distinguished between degrees of, on one hand, the degree of the particularly serious crime, and hasn't qualified danger in either limb. I'm not putting that very clearly.
No, not at all. I understood the point that was being put to me. Well, the argument I would put in response to that, which in my submission is entirely consistent with and is the basis of the UNHCR approach, is that when the provisions were drafted, the recognition had to be that 33.2 was a departure, as I say, from, resulted in, perhaps is a better way of putting it, the denial of a fundamental right, a right at the heart of the convention. In those circumstances, the expectation must have been that 33.2 would be interpreted restrictively. And that's really the approach that UNHCR is adopting. That's their interpretation. And there is a distinction in our submission between, I mean, whether the language, in one sense, whether the language of, I can't remember the language of the guidance, but whether the language of very serious is right. The key point in our submission that is underlying the approach of UNHCR is it's not sufficient that there is a danger. The danger needs to be sufficient to deny fundamental rights.
Well, the wording used is very serious rather than of a lesser order, and must constitute a threat to national security of the host country. It's not enough that it's a danger of doing some harm. It must be a danger to security of the country, which the discussions of the drafters indicated, and we've gone through this before, directly or indirectly to the constitution, government, territorial integrity, independence or external beliefs. So we're talking about extremely serious matters to start with.
Well,
we're not talking about that somebody will go and commit a robbery or whatever. We're talking about it will damage national security.
Well, I want to remind myself of the wording of the Refugee Convention. Thank you. If you look at the language of the Refugee Convention is merely talks about a danger to the security of the country. Now, the UNHCR guidance, ignoring for the moment the language of very serious, narrows that in one significant way, which is that the way my lord's put, because it describes particular conduct that is particularly serious and poses a particularly grave threat to national security.
Well, the drafters used the phrase "rather serious nature."
Sorry, you mean the UNHCR guidance?
Look at 654.
That's right. I was just. They used to give the language. The danger must be very serious and constitute a threat to national security. And national security, my lord pointed out to me yesterday, and this is, I think, the quote my lord was putting to me this morning, is footnoted at 15 with a quote from, I think it's a Lauprecht and Bethlehem article document, which talks about acts of rather serious nature endangering directly or indirectly the constitution, government.
Is that the document that Lord Justice Stanley Burnton was referring to, the latter part from Bethlehem?
I think that's right, yes.
It's meant to be summarising the discussions of the drafters. So it's effectively travaux, isn't it?
Yes, I think that's right. But my point about that is that what that is seeking to do. I mean, whether and it's one of the reasons why I think I prefaced what I just said, which about very serious, by indicating that one might need to be a little cautious about focusing overly carefully on the language of very serious. What this is intended to do, with the reference to with the footnote at para 15, is indicate that although the language of the Refugee Convention itself at 33.2 is in fairly broad terms, it talks about a danger to the security of the country. That has to, in fact, there is a higher threshold than that language might suggest, as demonstrated by paragraph 15, by footnote 15, and that higher threshold exists in part because it has to be, the threat has to be, or the danger has to be sufficient to justify the denial of fundamental rights, and that's the real point in one sense here, is that what SIAC did was said, well, all you need to do is focus on the language of the convention, and that simply indicates there needs to be a danger. What we submit is that whether the language of very serious is right or wrong, the fundamental point made in 14.1 is, and I have no problem in one sense with, because this would still suggest that we're right, that there needs to be something more than just a danger. The language that's in footnote 15 still recognises that it's not simply any danger. It requires essentially, to use that language, acts of a very serious nature, which positively endanger serious interests.
Well, that's the point, is this, when we're talking about very serious interests, and according to EN Serbia, we must look at a real danger. If you have a real danger to an essential national interest, wouldn't that outweigh the rights of an individual? Well, serious national interests are endangered. Isn't that what it's saying?
Well, one of the reasons why it wouldn't, I'm not sure necessarily the facts, but for example, if I think back to Raymond, I'm again thinking off the top of my head about it, Raymond in the Supreme Court, Raymond recognised that national security includes, for example, matters like good relations with foreign states. So you don't necessarily want to accommodate someone who is seen as being a threat to a foreign state. What Para 15 is recognising is that, or what footnote 15 rather suggests, is that it's not necessarily just sufficient that good relations are an issue. What you need potentially is acts that actually have in their own, in the way they're carried out, direct serious consequences for a serious interest of the state.
The context of this, and yes, of course, it's a serious matter, refouling a refugee, where their life or freedom would be threatened. But equally, it's an obligation on the state to give refuge to a non-national, and what, as I understand it, Article 33.2 is saying is that there you have that serious obligation. You are not obliged to do so where countervailing consideration is that the person poses a danger to the security of your country. And it seems to me that the purpose and context of that is pretty clear cut. That if they pose a danger which quite clearly, as EN says, is a real danger, the security of your country, as that may be defined, is enough to relieve you of that obligation. Well, it's difficult for me to see why you need to gloss that.
Well,
obviously it's a value judgment, I accept.
Well, the reason for glossing it is that, well, the argument for glossing it goes back to something I think I said yesterday, is that ultimately there is, logic says there's a spectrum of dangers, and some people are regarded as relatively low risk. They are,
yeah, and you might say a danger to national security is of the highest order.
Yeah, but they're still regarded as manageable risk. We don't, for example, and what all, I mean, another way of putting it, we've cited it. I'm going to take this out of order in one sense because I was going to go to AA Palestine, but another way of putting this is we cited in our skeleton a New Zealand authority, and we've actually produced, and I'm not sure I need to go to it for.
Just before you leave, I'm so sorry to interrupt again, Mr. Sully. Just before you leave footnote 15.
Yes.
The discussion is summarised as saying the exception may be invoked against acts, blah, blah, blah. So it doesn't say must only be. But this point about acts, it's not, it can't just be acts because the word is danger. And that's a point that's emphasised in the decision of, in Raymond in the House of Lords, to which you referred a moment ago.
Yes. And I
So that's another problem with that footnote, potentially.
well, I referred to the footnote in one sense, partly, I suppose, in response to a particular question. Our fundamental point about this, and I want, is that, and the footnote we would say is consistent with it, but it isn't necessarily the right way of approaching this, is that there is a distinction potentially between a test which simply requires consideration of whether there is any danger, and a test that requires a consideration of whether danger crosses a level that it justifies a denial of fundamental rights. And footnote 15, whether or not it's the correct way of expressing this, still underlying it is the idea that it's not simply any danger that is sufficient. And that's really the point I'm making about it. And that's consistent with the approach approach that's been adopted in New Zealand, which in itself followed Canada, and it followed Suresh, which is referred to in footnote 15. And to cut a little bit of a long story short, maybe just worth going to the Supreme Court judgment. We in our skeleton reference the Court of Appeal judgment, which is largely upheld, but with some nuances added to it by the Supreme Court. If you go to the Supreme Court in New Zealand, page 485 of the authorities bundle, starting point is just to note that para 42, they concluded there wasn't a need to balance the threat, which is arguably what the provision we saw this morning, the statutory provision, I can't remember the name of it, we saw this morning is concerned with. They emphasise that at para 44, the distinctions between the two limbs in 33.2. They emphasise the high standard because of the removal to dangers. They also emphasise the fact that the executive potentially has broad discretion. And in the end, what they decide to do, or what they conclude is right, is to adopt the approach that's been adopted in Canada in Suresh and indicate that the threatened harm must be substantial. So they do put what might have been said to be a gloss by the Court of Appeal in Serbia. They do effectively indicate there is a need for a threshold reflecting the seriousness of what is an issue. And certainly they understood, and we haven't put it in, but we understand that was the approach also in the Canadian Supreme Court. So that fits, we would submit, with the approach of the UNHCR. I should say, because I took it out of order, page 95 of the authorities bundle is the judgment of Mr. Justice Ousley, relevant passage of the judgment of Mr. Justice Ousley in AA, where it starts, the relevant passage of Mr. Justice Ousley in AA Palestine. He was considering, again, a slightly different issue, which was Article, page 95, paragraph 43. He was considering a slightly different issue, which was Article 1F, one of the exclusion clauses. At para 66, he addresses UNHCR guidance in the form of the handbook, the UNHCR handbook, dealing with what was meant by serious non-political crime, and effectively rejects it on the basis that exhortations of UNHCR may reflect the humanitarian perspective, wider than the Refugee Convention. Interpretation from UNHCR is entitled to great respect, but it may also be inaccurate or tendentious. In our submission in relation to that, firstly, that obviously preceded AAA, and in our submission doesn't fully reflect the importance of giving weight to giving weight to UNHCR interpretations. Here, what was an issue was a UNHCR interpretation. And it's a UNHCR interpretation, we would say, consistent with materials such as the judgment of the New Zealand Supreme Court in Zawi. And it's consistent with the structure, and so there's no reason for rejecting that interpretation.
But is it open to a court, while giving weight to a UNHCR interpretation, to say, we don't agree with it?
I've got to accept it has to be open to the court, because that's not what... AAA, although it indicates it has to be given significant weight, AAA is not a statement that UNHCR guidance is... It's not like the European Court of Human Rights, where it's charged with giving authoritative interpretations, and even in relation to that, obviously, they're not... Judgments of the European Court are not necessarily binding, so...
Yeah, all right. Thank you.
I'm not sure there's much I can say more about that ground. I think I've covered it all. The second ground is that SIAC directed itself quite clearly that it needed to adopt the approach in Begum and essentially adopt a public law approach to the approach of the Secretary of State, or the decision of the Secretary of State. You see that at paragraphs 138 and 152. Begum, I should say, qualified by U3, and I think we notified the court. I suspect my lady is well aware of this, that U3 was heard in the Supreme Court, I think 2 weeks ago, but nothing turns on that. Smith. Now, to be clear, and I think I've said this several times, but it's important when one considers what follows. We accept, applying the approach in Begum, that in one sense, the approach that SIAC has to adopt depends on the issue it has to decide. And that approach reflects the fact, at the very least, that what it's deciding is conditioned essentially by the test the Secretary of State has to apply, and depending on the test, there may be greater or lesser scope for the Secretary of State to apply judgment. Now, if we're right in our submissions in relation to the Secretary of State's grounds, the implication of that is that before someone can be, before someone's refugee status can be revoked, before they can be refooled, the Secretary of State has to be satisfied that the action they are taking is a last resort. And we accept, particularly given what was said in Begum, that in those circumstances it is difficult to argue that, and we're not seeking to argue, that SIAC should decide for itself, essentially, whether or not it's been established that revocation and or refoulement is a last resort. The approach adopted by SIAC in relation to this case to that issue, we accept, seems to fit with Begum. So if we are successful in resisting the Secretary of State's appeal, no suggestion from us that, in one sense, ground 2 of our respondent's notice needs to be addressed. If we're correct that danger means something more than danger, it means a sufficiently powerful danger, or a sufficiently significant danger that it justifies refoulement. Again, we recognise that there is more of a value judgment there, and it becomes more difficult still to argue that the Begum approach shouldn't be adopted. If the issue is simply, is there a danger, so we've lost on the first two grounds, then in our submission there is at that point a significant distinction between the situation in Begum and the situation in this case, because in essence danger is something that courts are well used to assessing. It is an objective question whether or not there is a danger present, and in those circumstances there is no real value judgment, very little value judgment involved in the exercise. And the approach in Begum, if one goes to the Authorities Bundle 248, starting point in Begum, which also was considered in U3, is that the test in that case, the statutory test under the British Nationality Act, referenced the Secretary of State's conclusions, essentially, about whether deprivation was conducive to the public good. You see that in paragraph 67. And the contrast drawn by Lord Reid is between that and SIAC being satisfied that deprivation is conducive to the public good. That is the context in what then followed in para 69, where Lord Reid indicates that simply saying that something is appellant doesn't necessarily tell you what the nature of the process that an appellate body has to conduct is. That process, slightly paraphrasing by letter F, depends upon the nature of the decision under appeal and the relevant statutory provisions. And Lord Reid recognises that even in the context of a single decision, different principles may apply depending on what's in issue. Now, if, as I say, we're in the situation where all of my arguments have so far been rejected, the language of the rules reflecting the language of the Refugee Convention is focused on danger. It's focused on whether there is a danger to the security of the country. That is, unlike under the British Nationality Act, an objective test. And on the face of it, we submit that in those circumstances, SIAC does have to decide the existence or absence of a danger. And that's, we submit, consistent with, certainly not inconsistent with, the approach of my lady in U3. And the relevant passages of U3 are at page 369, 370, where my lady recognises, obviously, the role that SIAC can have in making findings of fact, providing it doesn't ultimately substitute its own view for the view of the Secretary of State regarding risk to national security.
But hold on a minute. Sorry to interrupt, Mr. Southey, yet again. Is there really any difference between a danger to national security and a risk to national security? Don't they mean the same thing? Or very closely related things?
Two things we'd say. Firstly, where my lady is talking about risk to national security in the context of paragraph 174, that's why I started with Bacon, because the risk to national security is one that Parliament has expressly required the Secretary of State to assess. Second point that we make about that is that, and it goes back to the submission I made this morning about FAM, in the context of national security and deprivation of citizenship, the case law we would submit does indicate that what the Secretary of State has to do is not simply decide there is a risk. What the Secretary of State has to do is decide essentially whether that risk and the extent to which it can be managed justifies deprivation of citizenship. And that's what, in my submission, my lady is referring. I always feel slightly uncomfortable telling any judge.
No, go ahead. It's a judgment.
Yeah,
It's for you to
but it still doesn't.
interpret it.
Absolutely, but it doesn't change that sense of uncomfort.
What are the words mean objectively?
Yeah, it doesn't necessarily change that. What my lady is dealing with there, where you're talking about the risk to national security, it is shorthand in my submission for that. The fundamental question the Secretary of State has to ask it themselves, going back to what was said in Bagan, is this conducive to the public good? And what the Secretary of State is ultimately saying is, I'm satisfied that the risk here is sufficient, at taking account of, for example, matters such as whether it can be managed, to mean it's conducive. And that is a value judgment. It's not simply saying there's a risk.
Yes, but it's an assessment for the Secretary of State. I mean, it all goes back to the analysis in Raymond. Are you suggesting that that analysis doesn't apply to the question whether or not someone is a danger to the security of a state rather than a risk to national security?
I'm suggesting that if the only question is, what I'm suggesting is that there's a matter of domestic law, going back to Raymond, what was in issue was not simply whether or not someone posed a risk to national security or a danger to national security. I'm not seeking to say risk or danger makes a difference in terms of the concept.
Right, so you accept risk and danger are the same.
I'm not going to. Yes, I don't think I can.
All right.
What I'm suggesting is that under the certainly, for example, in Bagan, I think this is true of Raymond. The ultimate question was whether or not the action proposed was conducive to the public good.
Because of the risk of national security.
Because of the risk, but it wasn't. Yeah. It wasn't suggesting that there was. The issue wasn't simply is there a risk. Yeah. It was more complicated than that. It was a value judgment about the way in which one needed to manage that risk.
I don't think there's any chat about managing the risk. I think all the reasoning is to do with the fact that the Secretary of State has institutional expertise and institutional competence to decide whether or not there's a risk or danger to national security. And that's something that the courts lack, even SIAC. I mean, that's what Raymond says.
Well, if I can find the relevant passage in Raymond, because
and as I understand Bacon, the reasoning in Raymond is approved by the Supreme Court.
Yes.
And Raymond is a decision of the House of Lords anyway. So.
It is, yes. No, Raymond's binding, but and is a decision of the House of Lords. But
well, what Bacon does is firm up on Lord Hoffman's view in Raymond.
Exactly. I accept that. But if you go to sorry, no, that's a passage from Lord Slim, but I think still. It's page 245. No.
Are we looking at something in Raymond, or
We're looking at Begum's, the quotations. I don't think I couldn't remember if we've got.
Yeah, Raymond's in the bundle at start. It's at tab 14, starting at page 43.
Sorry. I thought we had Raymond, and I couldn't.
Page 84. Paragraph 56.
Yes. If you look at that was I marked the passage up, and it was the passage I was looking for. I was going to go to it earlier and didn't. If you look at by letter D, and it goes back in one. The reason I was going to cite it was to say actually what we're arguing for in response to the Secretary of State is not that different from the test applied domestically in other contexts. But by letter D, Lord Hoffman says the question of whether the risk to national security is sufficient to justify the appellant's deportation cannot be answered by taking each allegation seriatim and deciding whether it's been established to some standard of proof. It's a question of valuation and judgment in which it's necessary to take into account only a degree of probability of prejudice to national security, but also the importance of the security interest at stake and the serious consequences for the individual. So my point is here, which is that test in one sense is consistent with what we're saying in relation to the Secretary of State's ground and what we're saying in relation...
But the idea that SIAC can decide whether it's met or not is totally inconsistent with the rest of the reasoning of Lord Hoffman, isn't it?
But, my lady, going back to where I started from, which this ground only works, I accept, if we've lost on the first 2 points that have been... If we've lost on the first 2 points in our submission are consistent with what Lord Hoffman's saying, which is what Lord Hoffman's saying effectively when he talks about proportionality, etc., is it's not sufficient that any risk can be relied upon. One needs a sufficiently powerful risk, and that's something the executive is well equipped to assess. That, as I say, we would submit is entirely consistent with what we've said in relation to the first 2 issues raised. If we're wrong in relation to those, so you simply go back to the language of the Refugee Convention and all that is required to be established is danger, the distinction then arises between what's said in para 56 and the test that needs to be applied, and that distinction is there's no assessment, for example, of the extent of risk and the extent to which that is sufficiently powerful. All you're looking at is there a danger? And that is a more objective test, and that's the distinction we seek to draw.
That's, forgive me, throughout Begum, the whole tenor of it is that assessing considerations of public interest, which include considerations of national security and public safety, are matters Secretary of State.
But it's done in circumstances where the statutory those positions are expressed in circumstances where firstly the statutory test made it clear it was for the Secretary of State, and secondly, and probably more importantly in one sense, you're still what the court was still doing was carrying out the sort of balancing exercise described by Lord Hoffman, as is clear from FAM.
Sorry. If we look at 245 towards the end of paragraph 56.
Sorry, which paragraph, my lord? Sorry.
It's paragraph 56 of Begum, where Lord Reid is referring to Lord Hoffman, that although what was meant by national security is a question of law, the question of whether something was in the interests of national security was not a question of law, it's a matter of judgment and policy.
What?
That must apply a fortiori to whether something's a danger to national security.
But my lord, it goes back to the passage I took you to from Lord Huffman's judgment a moment ago, paragraph 56, which was one I was struggling to find, where what Lord Hoffman is doing in that paragraph is identifying what factors go into whether deportation, I think it was in the context of Raymond, was in the public interest, and that involved consideration of a range of factors, not simply the level of risk to the individual.
I think it's just misreading what is being said here.
Well,
I think it isn't just limited to the assessment of the balancing exercise. It's specifically concerned with the consideration of what is in the public interest as a matter of national security.
well,
Yeah, because he's dealing here with the argument that SIAC said, well, you know, the Secretary of State hasn't proved anything, and we find he hasn't done anything. And that's a slightly crude way of summarising it. And what Lord Hoffman is saying is, no, it's not a question of proving that X, Y, and Z have been done by the appellant. The question is a much broader one of evaluating risk. And that's, I think, what he's dealing with in paragraph 56.
well, in my submission, what Lord Reid refers to the interests of national security, he talks about whether something was in the interests of national security. So what he is referring to there is the linkage between concerns about national security and the action taken. And that's where the passage of Lord Hoffman's judgment I took you to comes into play. Now, to say, we're dealing with what maybe the hypothetical situation of me losing in relation to the earlier two grounds. But if I've lost in relation to the earlier two grounds, then the implication of that is essentially there is no sort of exercise of the nature described by Lord Hoffman in the passage I took you to. All you're looking at is simply whether there is the existence of a danger.
But the point about rape is a slightly different point, which is that all of those things that Lord Hoffman is describing in paragraph 56 are matters for the assessment of the Secretary of State. And subject to the limits that he describes later on in the judgment, the Commission can't go and second guess the Secretary of State's assessment. Isn't that what he's saying?
Well, that's not how I read paragraph 56, in that he starts at paragraph 56 by talking about the concept of the standard of proof. He talks about then how that standard of proof is not helpful when looking at the extent, and I emphasise these words, the extent of future risk. Why does he use the words extent of future risk? He uses that because his analysis of the ultimate question for the Secretary of State means that there is a need for a balancing exercise. So he's focusing on, in my submission, not simply is there a danger, is there not a danger, or is there a risk, is there not a risk. He's focusing on the need to assess in particular how significant that risk is, because that needs to be potentially balanced.
Yes, but all of that is for the Secretary of State to assess, subject to the limits that Lord Hoffman describes later on in his speech. So I'm not really sure where this gets you, because as I understand Lord Hoffman, he's saying these issues are not for SIAC, they're for the Secretary of State, and SIAC can only intervene in the limited circumstances which he describes.
Well, the risk of going round in circles,
yeah.
I'm not sure there's, in one sense, there's more we can say, but just to be absolutely clear, so there's no uncertainty about this.
Yeah.
Our primary position is, as I've made clear, not these arguments. So to get to this point, we're in a situation where all the Secretary of State has to do is demonstrate there is a risk.
Yeah.
Our point about that is simply that there is a conceptual difference between assessing whether or not someone forms a sufficient risk that it justifies the taking of serious actions against that individual, which involves assessment of, to use Lord Hoffman's language, the extent of risk and the extent to which that interferes with the individual's rights. That is clearly a value judgment, and it's a value judgment in passing that is for the Secretary of State, not least because the statute says that, which is where I started from with Begum. If all that's an issue is simply, is there a risk, that is something which in my submission is a more objective standard. It's a standard which the sorts of objections that were raised in Raymond and then Begum doesn't apply to it. I'm not sure there's much more I can say about that. But that's
all right. Well, we'll have to think about what you've said.
Yeah.
Right.
My lords, my lady, that covers everything I need to cover. Obviously, on the cross appeal, I have a potential reply in relation to that. But unless there's any questions in relation to anything I've covered so far.
No, don't think so. Thank you very much indeed.
And sorry for interrupting so much, Mr. Sullivan.
No. I have to say,
I've been very slow at times.
No.
Really sorry for interrupting you.
No, absolutely no need to apologise. I think when I sit, I interrupt too much, probably. But yeah.
Yes.
My lords, my lady, I don't think I'll be very long in my response. One of the phrases that my learned friend Mr. Southey, King's Counsel, uses throughout his submissions is more than a danger. And there might actually be some agreement between us. It is more than a danger that is required. It's a danger to national security. That's the point, and we would respectfully agree with the thrust of the questions and the statements made by my Lord Justice Phillips yesterday, and indeed I think you picked that particular baton up again this morning, because an assessment that someone is a danger to national security is a very serious conclusion to reach, and is only reached after a careful consideration of all of the material placed before the Secretary of State, and indeed material that's not placed before the Secretary of State, by way of specialised organisations who have specialist knowledge and who are specialised in assessing that type of material. And it's as a result of that assessment, and I took you to it in the judgment yesterday at paragraph 66 in relation to the first national security assessment. That's at page, core bundle, page 83, where it's clear that MI5 were involved in the assessment in this case. So it's core bundle, tab 7, page 83, paragraph 66.
So, I mean, in a nutshell, are you saying something along the lines that a degree of seriousness of the threatened conduct and its potential consequences is inherent in the concept of danger to national security?
Yes.
That's broadly speaking what your
Indeed,
solution
and
is.
I understood that was the point that my Lord Justice Phillips was making
Yes.
both yesterday and again today, because again, as I took you to yesterday, the conclusion in relation to D8 is that he's a danger to national security, such that his exclusion would be conducive to the public good, and that's what's set out in the correspondence. And therefore, yes, agreeing with what my Lord Justice Mills just put to me, already there has been a high threshold applied and met. And in our submission, that is all in line with what is in Article 33.2 of the Refugee Convention. And indeed, if you want to read in what the UNHCR have said in the guidance, that it actually meets that test as well. That everything has been considered with care, and the decision would not have been made without that high threshold being met. And of course, although, and a lot of the points are the same in reply to my learned friend's own grounds of appeal, the point is that SIAC, of course, still retains the power to consider whether that was an assessment that was reasonable or not, on the basis of all the evidence. And it can make factual findings in relation to the evidence as well, as Milady made clear in U3, and is demonstrated in this case. I think one of my lords or my lady pointed out yesterday, I think it was my Lord Justice Mills pointed out, that there had been a finding of fact in relation to voluntary reavailment, which was partially relevant to the national security case. So SIAC was able to make finding of facts in relation to that. And in our submission, when one considers those points, that really is a complete answer for us to my learned friend's submissions. And in our submissions must drive the court to the inevitable conclusion that SIAC got the test wrong. Just one other point, if I hope to assist in response on our grounds of appeal. My Lord Justice Mills yesterday raised an issue in respect of paragraph 75 of the decision in T. That is at paragraph page 617. Of the authorities bundle, and my Lord raised the question about why they had used the word serious reasons.
Yes, it's a translation from the French, isn't it?
It is. That's correct. It seems that the French version uses three different sets of wording. Article 14.4b, it appears to be something along the lines of reasonable grounds. Article 21.2 looks like serious reasons, and Article 24.1 looks like compelling reasons. So that must be the reason why. Those behind me have.
So instead of using the English translation, it's been translated from the French.
Yes.
Essentially.
Yes.
Yes. All right. Well, my judicial assistant was able to track that down.
Yes.
Thank you.
So I'm not sure there's any great point.
No, I see that now. I was barking up the wrong tree there.
Then dealing again very briefly with the cross appeal. Firstly, just for your reference, our written submissions in relation to that are at tab 15 of the core bundle, starting at page 190. They don't even look particularly long, but in fact they're even shorter because they cite the relevant passages from, in particular from EN Serbia and from Begum. So I can deal with them again, I think, very quickly. We submit that, as Lord Justice Stanley Burnton said in the EN Serbia case, that danger means danger, and that no gloss should be placed on the word. And again, I think it was a point that my Lord Justice Phillips picked up this morning. The test of danger in relation to what have been described as the two limbs in Article 33.2 is the same, and in our submission should be interpreted in the same way. If the drafters had wanted there to be a difference between the two, they could, for instance, have used the word serious in front of the word danger in relation to the first limb in Article 33.2. And so in our submission, what Lord Justice Stanley Burnton said in EN Serbia, even if it's not binding on this court, it's obiter, we would submit that it is at the very least highly persuasive. It is not a view that the court should depart from. And again, of course, just re-emphasising the point, in determining whether D8 is a danger to national security, we would submit that power very clearly falls to the Secretary of State to exercise using all the specialist knowledge and facility available to them. And again, moving to the last ground of appeal that my learned friend Mr. Southey dealt with, that is why in our submission it's clear that the passage from Lord Hoffman's speech in Raymond at paragraph 66 is binding on this court, that the It's for the Secretary of State to make an evaluative judgment on the basis of all of the evidence and material available to them. And it's not the role of SIAC to go behind that judgment unless, as I said at the start of this short reply, that it were to come to the conclusion that the decision of the Secretary of State had been unreasonable. And for those reasons we submit that the cross appeal, both grounds, both limbs, should fail. My lords, my lady, those are my submissions unless there are any other questions or matters that I can assist the court with.
No, thank you very much. Anything further from you, Mr. Sully?
Probably for the first time in my career, I'm not going to exercise a right of reply given the brevity of my learned friend's submissions. So,
very good. All right, well that concludes the argument. We will reserve our judgment. We will get it to you as soon as we can, but given where we are in the term, it's unlikely to be before the end of term, I suspect. When we do, it will be sent out in draft in the usual way for correction of typographical or minor factual errors. It will come with an embargo, which I know that you know, but I will say anyway, the court treats very seriously. I think that's all I need to say, apart from thanking you both and those supporting you for all your assistance in this case.
All right, please, then.